Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guests are Carliss N. Chatman, Assistant Professor of Law at Washington and Lee University School of Law, and Anthony Michael Kreis, Visiting Assistant Professor of Law at Chicago-Kent College of Law. They will discuss Chatman's essay for the W&L Law Review and Kreis's response. So welcome to the show, Anthony and Carliss.
Thanks.
Yeah, thanks for having us.
Yeah, it's my pleasure. And I think this is the first time I've done a essay and response interview. So this will be fun and an interesting new format. I wonder, Carlos, and I didn't want to spoil the surprise on this one because I really like the title of your paper. I wonder if you could start by just telling listeners what the title of your essay is and why you thought that this was an important intervention.
Okay, so the title of the essay is, If a Fetus is a Person, It Should Get Child Support, Due Process, and Citizenship. And this essay actually is the law review version of a Washington Post op-ed I wrote last year that started out as a tweet that went viral and has about, 400,000 people who liked it and about 200,000 people who've retweeted it. And it grows out of all of the abortion bans that happened last year when states chose to declare fetuses persons in their individual statutes to try to get around Roe v. Wade and other cases that permit abortion. So essentially, prioritizing fetal personhood over maternal personhood.
So maybe you could talk a little more specifically about those state laws, because I understand different states tried to do different kinds of things, and some of the different approaches are actually relevant to the argument you make in the essay. So I wonder if just briefly you could kind of give listeners who might not have been following that particular issue closely a sort of brief description of what some of those state laws tried to do and what they were trying to accomplish.
So they tried to ban abortion at the time of either a fetal heartbeat or from the time of conception, on the point of, making the point that human life begins at heartbeat or at conception, and using, to me, I think what they're trying to do is redefine, since the 14th Amendment defines citizenship and personhood as born, they are trying to switch when personhood begins to conception, or maybe even redefine born. It's unclear, in hopes that these fetuses can get constitutional protection and thus overturn Roe v. Wade.
So if I understand it correctly, then the idea behind the laws then is to sort of adopt a state-based definition of personhood for constitutional purposes in such a way as to render, at least theoretically, abortion unconstitutional on the ground that you can't abort someone who's a person, and if a fetus is a person, then they couldn't be aborted. Is that like a fair understanding of what sort of like the rationale behind these laws was?
I think so, and I think what's interesting is a lot of the opposition claims that they're not trying to do it across the board, that they're only trying to do it for abortion purposes, which is difficult. To me, just, legally, and just, if you're making a taxonomy of human beings and entities and things like that, it's like, how can you possibly change who a human being is? Like, I can change who a corporation is at any given time because we create them. But if we think of human beings as being created by a divine entity, it's very hard to conceptualize that we can give a right to a life and being, or any humanoid type entity, and then take it away.
Well, so in your paper, you observe that, as you just said, if we adopt the definition of personhood as attaching to a unborn fetus or a fertilized egg at a particular point in time, then that there are consequences that naturally follow from that definition in other legal contexts than abortion. And I wonder if you could just talk briefly about what you think some of those consequences might be and how they might, at least in theory, play out in practice.
Well, my favorite ones are, if you think about social safety net issues, healthcare, welfare, or SNAP benefits, child support, life insurance, like opening bank accounts and securing a child's financial future, and then jail and women who are imprisoned. What do we do about that? Like, does the fetus now have some human rights and constitutional rights such that a fetus can't be imprisoned? Can you deport a woman who is pregnant if her fetus is conceived on American soil? Like, is that fetus now an American citizen if we're changing when personhood begins? Does that change when citizenship begins? Because we have a birthright citizenship system. So I think it's, I don't want to say it's a slippery slope, but because I like all of those things, to be honest. I love the idea of letting every pregnant woman out of jail and not deporting pregnant women. But I think, you can't have your cake and eat it too. You can't deny women the right to an abortion because they're carrying a human being, a citizen of Alabama, a citizen of Tennessee, but then also keep that citizen of Tennessee in jail who has not committed a crime, or deport that citizen of Alabama to Guatemala because the woman who is in custody of them is not a citizen.
Well, so have any of the people drafting and adopting these laws purporting to change the definition of a person kind of grappled with this problem at all? Or, as you kind of suggest, have they sort of tried to wave it away or just pretend like the problem doesn't exist to the extent they've addressed it at all?
It's been, a lot of people hang their hat on statutory interpretation, and that, this is written into a health and safety code. It's not written into a state constitution, or it's written into the occupational code for doctors. It's not written. We only mean this definition of person to apply in this one place for abortion only has primarily been their rebuttal.
And how would that work, though, insofar as the right to an abortion is, according to the Supreme Court, based in constitutional rights? I mean, how can you redefine a kind of core concept in the abortion or reproductive rights context in one area but not in other areas?
I think it doesn't work at all. And I don't think it would. I think even if I were a pro-life person, I would have an issue with the way that these statutes are written and the way they're intended to apply. If I were a pro-life person who was also a lawyer and a law professor, I would either agree with me that you can't redefine personhood in one place. You can't redefine a constitutional principle in one place and not have it apply across the board. Or I would say we just can't redefine personhood on a state level. And that's, where I come down on it. I think, I don't hear much from the other side, to be honest. I do get some kind of, when the op-ed ran, I got some emails of, I agree with you, and that's why I think we shouldn't be taking this personhood approach, but I'm not going to say that publicly. So, the responses have been very, very interesting to me, in that I didn't get the backlash that I think other people get when they write op-eds or send tweets about reproductive rights. And I think it's because my argument is, it's based in the Constitution, it's based in logic. It's not truly a pro-life or pro-choice argument. It's like, this is just how our laws work and what the Constitution says and how federalism works. And you really can't do this unless we're going to, upset the entire apple cart.
Yeah, I mean, what was interesting and quite compelling about it to me was the way in which your essay essentially takes the arguments of the anti-abortion move to use personhood like at face value and just asks, like, well, what does that mean as an actual, what does it actually mean to do that in practice? Like, if we're taking personhood seriously in in a reproductive rights context, what kind of logical consequences flow from it.
Right. Right. Yeah. That's exactly what I was thinking.
Well, so Anthony, you wrote, I thought, a really interesting and thoughtful response piece to Carliss's argument, less directed specifically at her argument and more directed at sort of how it's situated in the context of the reproductive rights debate writ large. And I wonder if you could just talk a little bit about the intervention that you were making and why you thought it was important to situate the argument in this way.
Yeah. So I think first of all, like Carlos's argument is spot on. So what we're seeing here is this kind of two-step dance. There's this first step where there's an attempt to define personhood, right, under state law to challenge Roe versus Wade, and that's step one. And I think what step two is trying to get this emerging concept of personhood in order to use it as a vehicle to find a 14th Amendment grounded right to fetal personhood, right? So it's a long game. It's a short game and a long game. And as I'm looking at that short game and long game and thinking about Carlos's argument, for me, what I'm really thought about was, well, why is this happening now? And is that related? Is the timing related to the fact that what Carliss I think so wonderfully pointed out about how not well thought out these policies are, right? So why now, and why this kind of quick movement? And I just think it's really fundamentally about power, which I think abortion has always been about power and who has power over women and women's rights and bodily autonomy and the like. But it's about a lot more power than just that at the moment, right? It's to me, we're at a point in what I call constitutional time, which is this idea I'm working on in other scholarship now. But this idea that there are cycles of constitutional doctrine that develop. And they have a kind of coherent ideology. The last 40 years, it's been dominated by Reagan conservatism. But I think that we're at a point, what I call a slippage point, where that dominant coalition is weakening and is about to fade away. I don't think that the conservative bench that you see on the Supreme Court right now is going to last much longer, to be honest. And I think a lot of activists on the ground also know this. And so this is really fundamentally a movement that has cropped up because of Donald Trump and because of his two appointees on the Supreme Court. And these activists are looking at the judiciary as it's being remade right now, looking at demographic trends, looking at public opinion trends. And I think they realize that this is their moment to take action, and that if they don't constitutionalize their social vision for the country now, that opportunity is going to be lost. And so in many ways, to me, right, it's actually very reminiscent of the Prohibition movement, right? The amendment that adopted Prohibition was enacted at a point in time in order to cement, right, kind of this white rural Protestant American vision of what these folks wanted America to look like, and they did so at a time because they knew that with immigration and with changing demographics, that and urbanization, that time was not on their side, and so they rushed to create this constitutional movement, which ultimately failed. But I think the dynamics are similar.
I mean, it almost seems like a kind of revanchist movement in constitutional law that you're talking about, like trying to solidify a political gain that's about to dissipate in some way. And I wonder if you could talk a little bit more about how that ought to inform the way we think about constitutional law in relation to political change. I mean, what are we doing when we do constitutional law, especially when it's controversial?
Yeah. So, I mean, I think that there's a tension in legal academy because we want to believe that the law is different, that law is different than politics. And sometimes that's true, but oftentimes in the constitutional context, it's not. The constitutional law it's, constitutional doctrine is not just something that's out there in, kind of, I always often talk about it as being like in the ether, right? That it's just out there waiting for us to discover it, and that there's some objective right answer. I mean, constitutional law is really a byproduct of elections and social movements and political coalitions. And the only way that I think really law is truly made is when certain principles are adopted from one coalition cycle to another. So, for example, Brown versus Board of Education is the law of the land, in large part because Brown versus Board was not only adopted by the New Deal coalition courts and the New Deal coalition, but we've continued to adhere to it and adopt it and celebrate it in the next cycle of the Reagan dominated coalition. And I think that that's when law becomes really something different, is when a principle kind of lives beyond the coalition in which it was fashioned, right? When the next coalition embraces it as well, even if they're eating at the edges of it. And I think that's right. The Roe versus Wade, though, however, has been kind of different, right? In the sense that it was adopted towards the end of the New Deal coalition time of the court. It has been eaten away at the edges by the Reagan era courts. But the public opinion has by and large embraced abortion rights, which I think is quite interesting. And we're at a point in time where I think that the generational shifts are such that people still embrace abortion rights, particularly millennials and Gen Z. So I think that we're at a point, right, where abortion rights and Roe and Casey and these kind of basic principles of bodily autonomy for women's reproductive rights and reproductive justice might very well become very cemented and become not just politics or political results, but really become law in a way that we like to think about law, even though it's again, it's still a consequence of political actions and social movements. But I think we're at a point now where it's much more likely to be kind of path dependent and solidified. And that's what these folks on the ground in Alabama and Georgia and Iowa and the rest realize, that this is the last moment to kind of unstick Casey and Roe, and that this is, like you said, this is their last moment to do so, and so they're putting forth their best effort. Now, that might actually backfire on them, right? Especially if there's a large electoral coalition that rejects Trump, Donald Trump, and rejects Trump appointees and the Trump vision of society, in which case you have the opportunity for a totally reconstructed constitutional vision, which would reject that kind of worldview. So I think they're playing with fire, because on one hand, this is their moment. There's no doubt about it. This is probably the most politically powerful they've been in terms of both state legislatures and the courts. But the backlash that might ensue might wipe out all their gains in perpetuity.
Well, so I wonder if this says something important. This dynamic you identify says something important about the role of, or the place of, reproductive rights in relation to kind of constitutional politics. Because, as you know, right, I mean, the New Deal coalition, decided Roe v. Wade and created a constitutional right to abortion, sort of in its senescence, almost like the last moments of that, the Warren Court and the New Deal coalition. And then, we had this conservative majority for a very long time, but it doesn't seem to be really kind of focusing in on reproductive rights and on Roe v. Wade in a meaningful way until, as you say, it seems like it's kind of potentially on its last legs as well. I mean, I wonder what that says about what would happen. I mean, should the conservative majority today actually sort of follow through on its threat to overturn Roe v. Wade and kind of shift the balance on reproductive rights, would the move to a potential move to a more progressive or liberal court, do you think that court would be able to immediately reverse that move, or would that same kind of kind of historical unwillingness to touch the reproductive rights question right away until you don't have a choice anymore. Do you think that would persist? I mean, like, are we at kind of a turning point when it comes to that question or not?
So I think that a future court would be much more eager to reverse any attempt by the Roberts Court to undermine Roe or flat out overturn it. My future colleague at Georgia State, Eric Siegel, has written recently that he actually thinks that the court should just go ahead and do it. Right, to do what they want to do and overturn Roe versus Wade and overturn Casey, rather than dance around these kind of trap laws and different ways that the court has eaten away at the core right, because in his view, right, that it's better for the court to be transparent and for us to respond than for them to kind of hide the ball. And I think, I don't know what I really think about that, but what I do think is that if they were to do that, he's quite right in his long-term projection, I think, or his assumption, which is that the public would push back and would really, not only would it backfire on GOP candidates, I think, across the board, but particularly in the suburbs, and not only would it do that, it would probably foment more political realignment in a way that we haven't seen perhaps since 1964, 1980. It might reinvigorate calls to pack the court. The political pressures would really be quite severe on the court to reverse course. And I think if you had all those kind of ingredients put together, you would see a court, once the court's personnel might change a little bit, I think you would see a court that would be much more aggressive and eager to tackle on reproductive justice and reproductive rights questions, and quite just liberate the doctrine and reverse and breathe a lot of life into Roe and into Casey. So I think that's why I think the courts right now are being cautious, because they're going to get more, they will do more harm to abortion rights long term if the public or if they do it in a way that's not as salient to the public. And by eating away at the edges, I think they can get away with a lot more than if they attack the heart of the doctrine as they want to. And that's really why they're hesitant, because they know the long-term losses for them would be severe, I think.
Well, so Carliss, I was going to say, like, while your paper doesn't address these particular questions on its surface, it's very much kind of intervening in that conversation. And it feels like there's a lot of kind of implicit observations about the current political climate sort of embedded in the paper. And I wonder if you would be interested in reflecting on sort of your own thoughts on some of the issues that Anthony was just talking about.
Yeah, I totally agree with Anthony, and I like his analogy to Prohibition, because I envision what's happening now as, 40 years of incrementalism, like 40 years of just chipping away at it, death by 1,000 cuts for abortion rights. And I think that, those who are savvy in the pro-life movement prefer that approach to this sweeping overturn Roe fetal personhood approach, because people don't know what their rights are and don't realize that their rights have been taken away. And so you're right in that my op-ed is very much in the article now getting at, people don't know the full extent of what their rights should be. They also don't know which of their rights are gone and that existed before. People don't realize, and I should disclose, I was on a Planned Parenthood board for several years in Texas. People don't understand until they want an abortion that they can't get one on demand. People don't know that there's no abortion clinic in their state until they need one, because they think, oh, Roe v. Wade, Casey, I have a right to choose. And they don't understand what's been happening on a micro level, step by step, until it's gone. I've even had a friend who had a miscarriage, and medically, there are lots of things about abortions and miscarriages that are similar. And I'm not a doctor, so I won't get into it. But she went to get a prescription filled, and it was in one of those states where pharmacists have the right to deny you a prescription. And the pharmacist denied her the prescription she needed for a miscarriage because he thought she was having an abortion. And she was someone who was pro-life previously. And she's like, oh my God, I can't believe this person's infringing on my privacy. And how dare I have to explain to the pharmacist that I'm not having an abortion? And I was like, well, sweetie, this is what happens to women every day. And this is what you've chosen. This is what it means when we let, we let legislators invade our personal rights and our autonomy. And so I think because it's been so small and it wasn't a complete reversal, it can continue. Mm-hmm. But if it does, if we completely reverse Roe and Casey, one, I think the scenario that I talk about in the article, a system of tiered personhood or dual personhood where, in some states, a New York, a Washington state, all the West Coast states, all the liberal states, you've got full access and you've got, arbitrage of women going state to state to get access. In other states, you've got complete shutdown. And then I think you do have political upheaval in those states. A lot of red states are going to turn blue. A lot of, as Anthony says, the suburbs are going to revolt against the idea of having their personal autonomy taken away. And it's those moments, those one by one moments, of a conservative woman like my friend having those experiences that become exponential when Roe is completely gone.
Well, I know there have been some responses, Carliss, both to your tweet, your op-ed, and to the essay that we've been talking about. I wonder if you and Anthony could reflect on those responses a little, and maybe also talk about sort of where you think this debate is likely to go next.
I can start. I would say, if we go back to the tweet and the op-ed, you obviously, if you do anything that public, you get the crazies. So I discount the crazies as outliers, the, mailing pictures of aborted fetuses and, that kind of thing that happens when you talk about reproductive rights. So I discount those. The ones I find interesting are responses from people who are pro-life, who will say, I actually agree that, like, I believe in life so much that everything you say, I agree with. Like, we should 100% protect every aspect of human life. I don't know why we aren't protecting human life in that way anyway. I'm bothered by pregnant women being incarcerated, like just all in. And then then the third kind of angle is the have your cake and eat it too people who are, don't be absurd. It's clear that statute is only meant to cover that one thing. They're not trying to change the Constitution. They're not trying to change immigration laws. They only want to change what it means to be a person in their one state. We interpret statutes narrowly. The 14th Amendment is king. And that's kind of the spectrum, of what I've gotten personally. And I think, Anthony's probably better at talking about what's happening in the con law world in response.
Yeah, so I guess what I would say is to springboard off of what Carliss was talking about with this idea that people talk about, well, it's narrow and it's not this broad kind of attack on abortion rights across the board, or it's not this not well thought out beginnings of a social movement. It's a very narrow thing. When I hear those kinds of arguments, I think back to 2014, 2015, when a lot of state legislatures began to reconsider adopting state-level religious freedom restoration acts. And the argument was, well, RFRAs don't discriminate. RFRAs aren't, RFRAs aren't anti-LGBTQ. RFRAs aren't anti-women. RFRAs, and it went on and on and on. And in a lot of ways, it was kind of a response to the Supreme Court's interpretation of the federal RFRA and Hobby Lobby, right, which denied or which really restricted the requirements for religious employers to provide free contraceptive coverage for their employees. And so you heard all these arguments that this is narrow, but then you fast forward 4 or 5 years from that, and you start getting recently out of the Eighth Circuit, right? You actually get these RFRA-based decisions which actually harm anti-discrimination law and undermine anti-discrimination statutes. And so, the arguments that we were told 4 or 5 years ago were ludicrous and were kind of, taking things to their, logical extreme, actually manifested. And so I think that a lot of these arguments that we're seeing about, the narrowness of what places like Alabama and Iowa and Ohio and the like are trying to do, it doesn't really pass the sniff test, because I think inevitably what would happen is you get on the slippery slope where one or two states get traction with this kind of legislation, and the floodgates will get opened. And then the next question for activists on the ground will be, well, what's the next thing that we can do to trample on abortion access and abortion rights? So I don't buy that argument that is so often seen. But I think the reason why it's made so often is because it seems to be kind of I think it's the one that's most that tries to assuage people's fears and tries to kind of tries to package these pieces of legislation as being relatively benign and hiding what the long-term game is. And that's a smart strategy, but it also avoids the need to squarely address, right, all these other issues that Carliss and folks have raised about the implications of these pieces of legislation and what might happen if they're constitutionalized, and right, so they can make it look small, they can hide the ball in terms of the long-term games, but most importantly, they don't actually have to address the issue if they focus on the narrowness of it.
Well, Carliss, Anthony, thanks so much for coming on the show today. The essay that Carliss wrote was, in my opinion, really clever and provocative. And I think that this conversation has helped to illuminate some of the really profound issues about reproductive rights in a constitutional sense, but about constitutional law more broadly that it raises. So I really appreciate both of you coming on to talk about it.
Thanks for having us.
Yeah, thanks so much.
Bring your little fine self on home. Don't send me no message. You know I wanna know. I need you person. Bring your little fine self on home. Ain't no use to telephone me. I can't love no telephone. All the time you're telephoning. You could be coming home. Yes. Ain't no use to send no letter. I can't hold no paper tight. Ain't no use to send no message. It can't talk to me at night. Ain't no use to send your brother. I won't talk to no one else. Ain't no use to send your mother. You just gotta come yourself, little girl. I have suffered.